ASAP. Samuel Jones, the New Orleans liaison for ASAP, as the presenters. This agenda item will be presenting on best practices and insight on electronic monitoring of persons released on bail, pre and post trial. Now, folks, this is all as a result of that conversation that we had a few weeks ago when clearly the tragedy happened and there was a question as to whether or not electronic monitoring was utilized and what the best way is to do it. We know that we've got some deficiencies in our systems, and in an attempt to try to address those deficiencies, we need to figure out just where the holes in the bucket are. So these folks are actual providers. So we did not have a provider coming to present that side of it. We had end users talking about it, but we didn't have providers. So we asked them to come so that they could give us their perspective. And at the end of these discussions, we hope to be able to come up with a plan so that if we do move forward continually or expand electronic monitoring, we can put the best piece in place to ensure our citizen safety. So with that, welcome to the New Orleans City Council chamber, and you all can proceed.
Good afternoon. Thank you for inviting us. It's an honor to be here with you guys. My name is Matt Dennis. I am the supervising case manager of the ASAP program.
Jill Dennis, director of the ASAP program.
Samuel Jones, I'm the liaison person with ASAP.
So we have a lot that we can offer to say today, but I think the best thing to do is to let Jill. We just put together a little presentation for you guys today that could hopefully help address some of the issues that have come up. We did watch in the entirety the last Criminal Justice Committee hearing, and we took notes on every single thing you guys asked, and we're hoping today to have an opportunity to answer all of those questions for you. So with that, Jill will proceed with the presentation part of it.
So ASAP's mission statement is ensuring no one is stuck in jail simply because they cannot afford their bond by providing accountable solutions that protect public safety while promoting personal responsibility. We live by that statement, and every day we work hard to ensure that every word in that mission statement is fulfilled. The City of New Orleans can have the perfect supervision program that will be the envy of all other cities if it simply assists us in establishing a few guidelines with communication. Communication standards with NOPD, all divisions and departments in the criminal district court, OPSO, the DA's office, Orleans Parish Juvenile Court, and the judges. I think one of the biggest issues that we have right now facing supervised release is a communication gap. We have worked hard to fill that gap and make sure that every department is being notified as we can, but we do need assistance in being able to open the communication lines with some of these divisions and departments. We do recommend 3 standards be used when looking at a GPS supervision program. Those standards require that supervision program be a local company. It is hard for someone that is outside of the state of Louisiana, outside of the city in which the monitoring is being done, to be able to adequately supervise, monitor, and enforce the conditions that are being set by the court. Number 2, the supervision program must have a standard reporting process. This reporting process must include enrollment reports. These enrollment reports let each division of court know which company is monitoring that offender, what address we have on that offender, what phone number we have, what conditions we have, the next court date, all information that is pertinent to that defendant, and making sure that both the monitoring program and the court are on the same page. Violation reports. Every time a violation happens for a defendant, all those involved in that case need to be notified that there has been a violation. Court date reports. This takes all of the violations from the last court date to the present court date and puts them all together in one report, and it is sent before that court date each time. Monthly summary report. The monthly summary report is a list of all offenders in each division of court, lists their names, their case numbers, their conditions, and that way if anything had been changed, modified, or that way the judges can check to make sure that the conditions are adequate for that offender and where that case is at that time. Special request reports. This is anything from dot by dot report from the judge or any special report that the judges or the DA's office may want. Proximity reports. This is a big one. This is This is what we need to get NOPD involved in. We have an open door policy. If there is something that were to happen in Orleans Parish, a proximity report allows you to put an address in, and it checks for over our 170 offenders to see if anybody within our program was at the location of that crime. NOPD needs to have access to proximity reports at their discretion. And we are working tirelessly trying to make sure that each district of the police departments have access to the program so that they can log in and put in those addresses and be able to see if anyone within our program was at the location of the crime. The third thing is that a supervision program must have arrest powers. That is very, very important. If you cannot enforce the conditions that are being set by the court all the way to the point of arrest, then enforcement cannot happen, and enforcement is a very big component to what we do. We cannot simply have devices on ankles and simply notify the court, who then have to issue an attachment, who then have to wait for NOPD to go on. So if someone cuts off their device, it could take days in order for things to start moving, where with us we have immediate arrest powers when the release is associated with a bail bond. That is a very important aspect to the supervision of offenders, both pretrial and post-conviction.
Let me interrupt you for a second. Of these recommended standards, which of those are currently being done in Orleans Parish?
These are standards that we operate under. These are standards that we suggest every provider operate under. Probably the biggest difference between us and every other provider is they refuse these standards. These standards establish accountability. They eviscerate deniability. And some of the biggest problems we've had in our community with past programs is they're built with 100% deniability. It's not my fault, it's the judge's fault. In this case, if somebody does wrong in our program, it is 100% our fault.
So, make sure I understood.
Yes, sir.
What if these recommendations is happening with the companies or the providers or whatever the right word is in Orleans Parish? What if that is being done today?
This is the standard that ASAP operates under.
And is that a national standard, or is that just your company's standard?
This is a standard that we established based on many different things. The reading of the Inspector General's report from 2015, the current status of ankle monitoring. If you're going to hang a device for profit, then you really don't want to have standards. You just want to put a device on a leg and make money. You certainly don't want to box yourself in. So by doing this, we box ourselves in. We make it impossible for me to pass it off on you or the judges or NOPD or whoever. So to answer your question directly, people don't want these standards. People in the industry of ankle monitors do not want these standards. These standards would make the ankle monitor program transparent and fully accountable. We think this should be the standard in Orleans Parish.
So help me then from the other way. What happens today if a individual who has a monitor cuts it at 12:30 on Tuesday? when does the violation get reported and when does that person actually get dealt with?
Okay, so I understand that there's a two-part answer: the others and then us. The
Well, I'm
others,
talking about the others. I want to know what's happening now since your standards
now
are not what the
understand
others
that
are
90
doing.
plus 98% of all people supervised currently on release through ankle monitors in this city are supervised by us. There's very few others that aren't. So I can give you examples, exact examples, but they're not really relative to Orleans Parish. If a person cuts their ankle monitor off in Orleans Parish, we know. We know right away, and we activate enforcement mechanisms. And this packet, if you want, is some examples of that. We have a person that cut his ankle monitor off Friday. Within an hour, he was in jail. That's a rape charge. That's an undocumented immigrant who is extremely high risk to fail to appear and to potentially recommit a crime. And he cut his ankle monitor off, and 1 hour later, he was taking up space in the Orleans Parish Jail. Other programs don't have that mechanism in place. They don't have the ability to make that arrest. So what will happen is they'll receive a digital notice through their program that a person has violated, whether it's an exclusion zone or cutting off their device, and they'll make a note in the system and they'll hit submit, and the judge will get a report. And if it's Friday at 4 p.m., the judge will see it Monday, and this is the natural way of things. Our program is different in the sense that I get the alarm that he cut his ankle monitor off. Within a few moments, our people are en route to his location. Within 1 hour, he's in handcuffs and in jail. And then shortly thereafter, a report is sent to the judge indicating that that person was arrested and why.
Now clarify for me, how many, and did I hear you just say you got 98% of the people in Orleans Parish in your
We
program?
probably have closer to 100%, but I'm sure there's a few that we don't have, yes. If the judges prefer this program, it's the only truly accountable program available to them.
Okay, so if your program is operating with these standards, then, and you've got almost 100% of the people who are being monitored electronically, there should not be any issues with electronic monitoring, correct?
Well, except for the fact that you don't have perfect lines of communication coming down from all of the players. The judges are the who watches the watchers question. It's the judges. The judges are who initiate this process when it comes to court orders. So when a judge issues an order for a person to be released to an ankle monitor, that information has to make it to a provider. If it doesn't make it to that provider, then that person risks being released without an ankle monitor. Now, we've worked very closely with the sheriff's office to make sure that they're able to receive the data they need so they can reach out to us. Believe it or not, we get a lot of phone calls at midnight. Hey, Johnny's coming out of jail. He needs an ankle monitor. Are you guys the ones doing it? And that's the first indication we got that someone's coming out. That's why our first slide is help us create the bridge of communication that we're missing.
So how does it work now? If the bridge of communication is not there today, somebody got let out 10 minutes ago on an ankle monitor. What happened?
Well,
walk through the process for me. I need to understand
we have two different types of
where this
judges.
went.
We have two different types of judges. We got old judges and we got new judges. We really haven't had a problem with a lot of the judges that have been sitting on the bench for a while because they recognize to either through their clerk or through the defense lawyer or through the prosecutor to get the defendant to get word to us. But when you have a newer judge that just sat on a bench recently, they're not really in that loop, and they make a mistake and they forget to put it in the bail order, so it doesn't make it to the sheriff. So when the sheriff does his release, he doesn't see that there's an order in place, and nobody knows.
So is the fix of that an orientation with the judges who are not aware of what the process is? How do you fix that?
Sure. Well, the first thing I would do is develop a set of standards as it relates to court orders. Make sure that there are a set of standards that the judges can latch onto and say, this is how we expect you to operate. Because if you got the watchers watching us, but they have no ability to do anything, what good is it? If my whole job is to just tell you, Councilmember Banks, this guy split and he's gone, I notified the sheriff, and that's it. That's my job. That's a broken system. That's not going to work. So the judges have never had this level of communication back to them. See, remember, the judge is sitting on the bench looking at, and I want to be clear on something. The sheriff said at the last Criminal Justice Committee hearing that we had a right to refuse. We have a right to refuse to enroll people in our program. And the sheriff's representative made it very clear, we won't enroll these people. We don't have low-risk, nonviolent first-time offenders, not one. Every single person in our program is this city's worst of the worst. We have armed robbers, carjackers, rapists, kidnappers, and murderers. These are people that never used to get out of jail. Just 7 years ago, under the sheriff's program, he didn't have these people. The need to reduce our prison size and our population has pushed a momentum forward that has caused judges to take greater risks. So now you have a black-robed judge sitting there going, I need to let this guy out. For whatever mechanisms in place that forces that judge to let this person out, that judge's reputation, their job on the bench, it's all at stake. If they latch themselves to the wrong program and this guy breaks away and runs, that judge pays the price for that. So the judge needs to know that they're getting a program that is accountable. So how do you get all these judges on the same page? I do not have an answer for that.
So wait, let me make sure I'm understanding you. And obviously my naivety is showing. The violent offenses that you just talked about, murder, armed robbery, rape, all of those things, those people are let out on electronic monitoring?
This is a person that was released on a murder charge incorrectly. When it was determined that the 10-2 conviction was actually not a 10-2 jury, there was an immediate need for his rearrest. The judge in this case did not call NOP. They did not call the sheriff. They called me personally, and within an hour, I went to St. Bernard Parish. I put Ahmaud Rainey back in handcuffs. I put him back in the Orleans Parish Jail to finish his 38-year prison sentence for murder. This person here, I'm not going to say his name. You guys can have these. I don't know. It's a public records, all of this stuff. But I'll just start reading a couple of his charges. Armed robbery, aggravated assault with a firearm, false imprisonment with a weapon, false imprisonment with a weapon, aggravated assault with a firearm, ag battery, ag battery, ag battery, ag battery. And this goes on for 6 more pages. It includes a dozen violation of protective orders. He was in my program. He violated the judge's order. I arrested him within minutes of her ordering me to arrest him, and I returned him to the jail where he sits today. And this is the rapist. This is a guy that's charged with rape. He's an undocumented immigrant. He's in this city. He cut his ankle monitor off, and within an hour, we put him back in the jail.
But and this may not be under your wheelhouse, but I appreciate the fact that you are proficient enough to go and pick him up. My question is, how did they get to you in the first place? If you've got somebody that's got 6 pages of aggravated anything, in my mind, he should not be eligible to be outside of confinement. Now, if it was urinating on the sidewalk or littering or something that did not endanger human life, then okay, I can see letting him out. But maybe the start of this needs to have some standard as to what's acceptable to be put on electronic monitoring. Because again, man, if you got 6 pages of aggravated anything, that to me ought to disqualify you for me trusting you that now all of a sudden you're going to play within the rules because you are out on the ankle monitor. That's counterintuitive to me. I don't see how that logic works. So that, again, I realize that that's not in your wheelhouse, but if you've got a whole stack of them there like that, then there's definitely something wrong with this system, and I'm not sure if we have the authority on the local level to legislate a standard, or if we've got to get with our partners in the legislature to create a standard. But that's not a hole in the bucket. That bucket ain't even got a bottom in it. All right, that's past the hole. Nobody should be out with 6 pages of aggravated anything. That makes no sense.
Listen, I can't disagree. I will say this. If I was sitting here today giving you a stack of people that were on ankle monitor for urinating on a sidewalk, we would have a serious, serious problem, because that is so beyond necessary. Low risk, nonviolent, first-time offenders should not be in jail. They should not be forced to make bail. They should not be in my program. This program is an intense program. It is designed to supervise people who are at a much greater risk level. So with that said, the judge is elected. They wear that robe. They went to law school. Their job is to set bail based on history and charges. And when a judge tells me this program needs to accept this person, we accept that person, and we make them follow that judge's order to the letter. And when they don't, we arrest them.
Well, I'm going to tell you, I'm not a judge, but I would not think that the low-risk person shouldn't be in your program. I would think just the opposite. The low-risk person ought to be in your program to make sure that there's space for those high-risk violent offenders that have threatened my family and yours. This absolutely makes no sense. And again, with all due respect to the judges, they're independently elected. You're right, they went to law school, very nice people, I'm sure. But at the end of the day, there is definitely something wrong with the system. We got the cart, hooked up 3 blocks in front of the horse. This doesn't make any sense. If your whole program is violent offenders, just by the nature of that, that ought to be who the jail is for. Now, I am 100% in favor of reducing the prison population, but that is with frivolous, non-lethal, non-violent, non-personal offenses. There needs to be enough space to lock the bad guys up. When you violate somebody, that ought to be it. Because it could be your sister, my mama, her cousin, or anybody else. We don't need to have open cells and people that are a threat to other human beings running around. That just doesn't, and maybe it's me, maybe I'm delusional, but at the end of the day, something wrong with this. This does not make sense. And I would be curious if you could, and I don't know who would have it, to find out if there is a roster or a listing of the judges that are putting these kind of violent offenders on ankle monitoring. I would love to be able to have a one-on-one with them to find out what's the rationale. Why does somebody with 6 pages of aggravated whatever warrant being let out back into the public? There has to be some rational reason. There's got to be some logic somewhere. Now, I may not agree with the logic, but there's got to be something somewhere, because I'm going to tell you, man, my little feeble mind ain't smart enough to process that. 6 pages of aggravated, you need to be under the jail. You need to be waiting until your trial, and if you're found guilty, then you need to be put in the place to place your debt to society and not running around out here with a moniker that you can cut off. You done blown me away, man.
I have 28 years experience in supervising people pre and post trial that are released from jail in this city and around the country. And I can tell you that there have been a large number of changes made to criminal justice. And what we've seen is an end result. At the end of the day, every single person that comes in front of me that I deal with as an individual, I can look at their charges and I can try to make an assumption, but I know that every single time a judge makes a decision, it's their decision to make. And what I do is I don't refuse to take the people. If the judge is going to say put them out there, we have, again, look at this case here. This was a 10-2 jury conviction overturn. This is a gentleman that was convicted of a murder. Should he be out? The jury was over. There was an improper jury verdict. The DA made a determination he needs to get out. Some would say, if they agree with you, that he's too violent, he should stay in. Others would say, no, he should be able to get out and be free and protect his family. Here's what I say. I'll watch him for you. I'll make sure he does exactly what you want him to do. And if he doesn't, I'll put him in jail. And I'll report it to you however you want. Do you want to know before I put him in jail? Or do you want me to report it to you first and let you decide? It's up to the judge. And I don't get to tell the judge what to do. But I won't say no to the judge. I'll do the job if they want me to do it.
And I don't want to give any inference that I am in favor of just arbitrarily locking up people. What I am in favor of is keeping this community safe.
I guarantee.
And while if that gentleman was overturned because the law changed and it was no longer a unanimous jury and they needed to deal with him in a different way, his set of circumstances are far different than somebody sitting there with 6 pages of aggravated.
No doubt.
Now, I do get that there is a nuance here, and by no means am I in the belief that everybody ought to just be locked up forever, because you do have innocent people that have been affected by the system. We definitely need criminal justice system reform. But at no point can we lose sight of the fact that we still need a criminal justice system, because there are very violent people out there that will prey on the rest of us. And if you keep letting the revolving door spin, they could introduce themselves to one of us in a way that we don't want to be. And that's where I am with this. So no, I don't want to infer anything about just saying let them all out and lock them all up. Either way, there is a nuance here, but common sense has to come in play. And again, 6 pages of aggravated anything would indicate that's probably not the best guy, and I'm assuming it's a guy, that's probably not the best person to be trusted to just be out on his own. That just doesn't make sense to me.
Well, in that one case, I'll just add one thing. He was very, very much under a microscope of the judge. She made it very clear she wanted this man under very tight restrictions, and he was. So I'm not making one way or the other on her decision. It's the judge's decision. So I receive people based on an order from the court, and I respond based on that order. I leave the decision making to those
And
people.
just let me make sure I understand. He was awaiting trial or he had been convicted?
He is awaiting trial.
He's awaiting trial, and those 6 pages of aggravated things that you have, were there convictions in there or are those just arrests?
This is all 100% from a single arrest, if you want a copy of it.
So wait, he got 6 pages from a single arrest?
That is correct. It's all one
Help me
arrest.
understand that. What, it was multiple victims, or what does that mean? The 6 pages from a single arrest?
I mean, I don't know. I don't know the answer to that. I can tell you the charges. I don't know the circumstances of the charges. That's not the details that I pay very close attention to. There's one for each if they'd like it. Is what the judge says. The judge says absolutely 24-hour home incarceration. He's never to leave for a moment. If he does, you let me know immediately. That's what we do. The judge voiced the concern that this was a very, very serious charge and that he was going to prison. And she wanted to make sure that he didn't go anywhere, that he was available for that date. So
But
that's
wait,
what we
hold
did.
on. If he's going to prison and it's a very serious charge, isn't the likelihood of him getting out of a jail cell a little bit less than the likelihood of him walking out of his house, even though you're proficient and you went
I
to get him?
agree, yes.
Wouldn't it have made more sense to keep him under sheriff's confinement than to let him out? I'm not understanding.
That's a very easy answer to give.
Sir, he paid his bond. Once you pay the bond, it's up to the judge's discretion to make you have home incarceration. The majority of the time, the judge will say with all that lengthy arrest that he's on home incarceration.
Even though the judge said that he's going to prison?
No. Remember, he's innocent until proven guilty.
But your partner just said that the judge said he was going to prison.
Absolutely. The judge said the
I
charges.
mean, you look at, it's also one thing you have to keep in mind. It's not what the police report says, it's what they can prove in court also. It's just like you get a ticket and you get multiple violations. You still have to go, you have your day in court.
And trust me, man, I'm not trying to take anybody the right way, and I fully appreciate the fact that you're innocent until proven guilty, and I want everybody to have all the access to justice as they can have, but I think that at some point, common sense got to come in this equation some way.
We have to find that balance between our job is to supervise based on an order that is written out in clear language, and we just follow that order to its letter. We have to find that balance between understanding what their charges are and the potential risks and trying to be impartial and just do the job that the court's given us. And it's tough because some of these people, to be quite honest with you, are scary. Some of these people that are out of jail and in our program are scary. But at the same time, many of those people that are very scary and in our program are doing exactly what they're supposed to do. But the one thing I tell everybody is the make or break day is trial date. Because you can be perfectly good all the way up through the 67 appearances that precede your trial. But it's that one day that matters the most, the day of trial. Will they show up for court? So, I mean, listen, there's a tremendous amount of risk in letting people out of jail pre-trial, period. But it is a constitutional right. It is protected. It is the right thing to do in most instances. All I can tell you from our perspective is when a judge gives us a court order, we're going to make that person follow that court order to the letter because we are the only program in the entire state that has the ability to arrest you if you don't follow that order.
And how did you get that authority?
Because this state regulates and licenses its bail agencies. And what I do is make all of my enforcement agents have that license. That way, when they team up with the bail bond company that wrote the bond, they can make that arrest using that bail bondsman's authority. While ASAP is not a bail bonds company, it doesn't write bail, it doesn't produce bail, it doesn't get people out of jail, it does partner with those arrest powers that come from the bail bondsman, and it's important to them because they have an obligation as well, and they stand to take a terrible financial loss as a penalty if this defendant does not appear in court. So having the bail bonds company lend us their arrest powers makes it this one of the most perfect programs that the city's ever seen.
Councilmember Glapion?
When you say lend you their arrest powers, are your folks post-certified?
All of our folks are licensed and regulated by the Department of Insurance, which is a requirement to be able to have arrest powers. It's spelled out in the revised statutes and the Louisiana Insurance Code.
So I'm not clear if that's a yes or...
Well, the only people that go to post-certification are law enforcement, police officers, things of that nature. These are a Department of Insurance regulated and licensed entity that get people out of jail and have full arrest powers in the event they fail to appear in court. What bail has done is added to its responsibility list, making sure that they follow the entire court order.
And so your folks are fully licensed to carry on
They must be.
and have full arrest?
The law requires it.
Okay. But not by any law enforcement?
There's no post-certification. That's only for law enforcement personnel like sheriff's departments, police departments, and such.
Gotcha. And back to the proximity reports. Tell me a little bit more about that. So you said the NOPD should have access at their location to those?
Yes, ma'am.
And is that something you would share with them? Tell me it. Just
We have
explain it to
reached
me.
out to Chief Ferguson by email. I have not received a call back. What I would like to set up is each district of NOPD having a login and a password to be able to log into the system
By district.
and then be able to put in an address and then be able to verify if an offender was at that location or not at the time of a crime.
Okay. And so you said you've reached out, but you haven't heard back.
That's one of the communication situations that I'm hoping we can rectify through this meeting.
Listen, I want to add on that. We get 1 call, 2 calls, 3 calls a day from various NOPD, whether it be homicide, different district. The 8th district currently has my personal username and password, and there's 2 detectives there that use it, and they kind of share it with the whole district because we have to one-off this. When the Brian Andrew case came up, within 2 hours of that murder, I was on the phone with NOPD detectives and the DA trying to figure out who had this person on ankle monitor. They called me, and I worked with them for a number of hours to get to the bottom of that. And I was comfortable at the end of those few hours that this man never wore an ankle monitor. He was released without it. The problem isn't that they can get to me and have this communication. The problem is piecemeal. What if a detective doesn't know to call me? I have a detective that starts off with, I spoke with Detective so-and-so, and he said I should call you. And this is how it's getting around, and it's very slow. So when we talk about proximity reporting, we don't think a police officer should have to tip his hand. He shouldn't have to reach out and say, hey, can you look this up for me? He's in the middle of an investigation. He should be able to look at that confidentially himself in his office, on his computer, and conduct his investigation in a classified manner without showing his hand to anybody. That's why it's important that they have it themselves.
Okay. And short of that, is there a list of any kind? Does the police department at any point know who's on electronic, who's being monitored electronically?
We do have a monthly report that goes out from ASAP. However, I just had a situation where we had a gentleman beat up his wife and kidnap the son. It took us the NOPD called us because they usually call us. It took over an hour to find out who was monitoring that offender, find out where that offender was, and to get that child to safety. The guy was in jail that night, but it should not have taken as long as it took. We should have been able to go into the docket and see who was monitoring that offender. That is very, very important, that information, and that's when we go into making sure there is a standard reporting process. That way everybody knows. If you look at Article 894.2, and we'll get into that later in the presentation, it does deal with post-conviction, but it does say to allow everyone that is involved in a case to know how to contact the monitoring company, who is monitoring that offender, and what their conditions are.
Okay.
I would like to,
Councilmember Wynn?
Yeah, I just wanted to piggyback. Well, first of all, thank you for being here, and thank you for giving me a tour of the operation. And so I was really impressed with it. And I guess it was more of having standards of procedures in place, kind of like the SOP. So in that way, no matter which ankle monitoring company is working with the judge, that there's a standard procedure that every company follow. Because I think that while you guys may be doing a great job in making your clients, but what about other agencies that the judges are using as well? And that, so I think a standard of procedures, and I really believe, Jay, that we need to have a conversation with the judges. They need to be at the table. I believe that they are the elected body that needs to establish the standard of procedures, and that way everybody's on the same page. Because God forbid, we don't want anybody that is in the program and that there was an oversight because they were using a different company. I think we've seen that more often than enough, and I think it's time for us to correct the wrong, and by making sure that we start with a standard procedure. So in that way, if A, B, C, and D is at the table, everybody has the same rules. They have to follow the same procedures in reference to all situation. So that's just my thoughts on it.
And let me, just for clarification, because you said something that raised a flag for me. You've got detectives that reach out to you. What is the official communication or notification with NOPD?
If they call us to request information, we do have them email.
No, let me go from the other way. If you all have a individual on monitoring, there's no requirement that the NOPD know that this person is no longer at Tulane and Broad, that he's now at his house on XYZ Street?
No, sir.
So if I'm not a friend of yours and have your number and I need help, how do I know what to do? Shouldn't there be some official line of something between you and NOP to let them know that I've got 100 or 10 or whatever the number is people under my jurisdiction, and you all need to know that they are aware in case there's a problem? Wouldn't that make sense?
Well, that's why our first slide covers communication, that if we could bridge that gap, we could end up with a communication standard that would allow for it. Again, when you look at the standards that we recommend, part of that is that reporting process. The moment a person is enrolled and you get on our computer to do the enrollment, when you hit submit at the end of that process, it automatically emails everybody under the sun that you want it to email. So if somebody calls me and says, give it to my clerk, here's her email, when I hit submit for Division D or whatever, it's going to go to whatever criteria we have set up, the judge, the clerk, the sheriff, the DA. Everybody will get an instant notification that they're in the program. You know, I want to add one more thing on the standards, just so you understand. You know, the Paul Bonin issue that was addressed, I think, correctly by Court Watch NOLA, indicated that you have a politically connected group of people that were paying, I mean, essentially, I guess campaign contributions, if you want to call it that, but they were giving this judge money, and this judge was filling their coffers with people on ankle monitor. He wasn't just sending them new business, he was ordering them out of other programs and into his friend's program. That is totally and completely inappropriate. And I applaud Court Watch NOLA for the work they did. And our standards process helps address that. We don't believe any judge should send a person to a specific program. They should send them to a set of standards. If the judges recognize that there are an established set of standards that keep everybody above board and honest, then the judges can be safe in knowing that whatever provider the city has, they're going to do it properly. Without these standards, there's no ability to make sure that everybody's operating correctly. If you want NOPD to know the minute a person gets out, we got to develop these standards. Without you guys leading to get NOPD to communicate, they're not going to communicate. It's just not going to happen. Without you guys leading to get the DA's office to communicate, they're not going to communicate. Every single elected entity is its own little kingdom. I certainly can't tell them what to do, but we will provide you the tools you need if you want them. So
I have not had this conversation with the superintendent of police, but I know him to be a responsible man. I am positive that he would not be opposed to receiving information from you that will help him and his officers do their job. So what do we need to do to get that confected? Matt, call Sean for me. I'm going to try to get an answer for you right now.
Our very first slide, Councilman Banks, describes what we need. We don't want money from this city. We don't need permission from this city. What we need is communication with this city. This way, There's no more piecemeal. I
So
shouldn't
the
get 2 o'clock in the
communication needs to be between you and the police and whom else?
how do you go backwards?
The DA office
Yeah,
also.
the
Well, the DA is an independent elected official. Him I have no fiduciary or
If
legal
this was
authority
perfect-
over. I can talk, however, to the police chief directly, and I will certainly call the district attorney and ask him if he would be amenable to having some mechanism put in place to have this established. This doesn't make any sense.
We currently send a monthly summary to the DA's office. They have that. How they use it, we don't know. We currently clock every single report into the court record. That way anybody can see it, the judges, the clerks, the press, you guys, whatever level of communication this body would want to help us with, it can't hurt. You can't grease the wheel too much.
And
So-
then if there's no communication with NOPD, then there's not likely to be communication with the victims either, right?
We're not having the communication link is not established in a way that is organized or easy to identify or trackable, or it's not there. There's no communication with these entities at this moment.
See, because I think that makes a bad situation worse. If you've got a victim who has already been traumatized by an individual and they are resting under the belief that that person is no longer a threat because he's incarcerated, and then they happen to be at Winn-Dixie and see him in the line, that's got to be a terrifying thing.
Well, we have one of the programs that we've brought. We'd like to bring solutions. We'd like to look at an issue and try to find a solution for it. So as it relates to victims, it's unfortunately not something that's being used enough in Orleans Parish. It's being used in our other parishes quite a bit. A lot of the domestic violence problems that we face, we have one of our pieces of equipment allows us to connect it with a thing called a fob, which is basically a victim fob, which addresses what you're talking about. It allows a victim to know real time if the person that violated them is breaking that little mobile stay away zone. Another interesting thing about our program is we do something that no other program does. Every other program that you're ever going to come across is a one-trick pony. They bring you an ankle monitor. They say, I'm going to hang this ankle monitor, we're going to do it this way. We don't. We bring you wristwatch monitors, ankle monitors, phone app monitoring, alcohol monitoring, victim notification programs. We have a whole group of things that we bring in under an umbrella, and we offer it out. And these are all different competing platforms that we bring together. That way you have this wide variety of choices for a judge from least restrictive to most restrictive.
And I want to be clear, you all have tried to have communication with NOPD and it didn't happen?
We have communications now with NOPD in a very piecemeal way. It grows every day.
But I want to be clear that
There's
anyone
no
in your
order-
shop,
we
no
have
one in
no
your shop
direct-
has reached out to the superintendent to get something comprehensive.
We have
Yeah.
no direct liaison with the NOPD.
That is correct.
Okay.
Someone we can call. But, not to interrupt you, but let's address what brought us here today, okay? What should be focused is on, an individual had a $245,000 bond, okay? That bond was reduced to $95,000. He paid that bond and he was released. He was shipped over to Jefferson Parish, where he had a $15,000 bond. That bond was paid, and the guy was released in the street, okay? Then this lady, unfortunately, was murdered. Okay? And then this what brought us here today. Accountability. That's what we need. Communication and accountability. And I think we should focus on how did that bond drop from 245 to 95.
Well, I just think that's a layer in this cake. I am more concerned about not just the bond being reduced, but a whole process that would allow apparently a lot of steps to be missed. So if you tell me you got two different parishes with jurisdictions with someone who was arrested on a violent offense and nobody caught the fact that this person was able to just walk out of jail and end up subsequently committing a murder, that's a real big problem. So not only is it the aspect of the bail reduction, it's the fact that there needs to be a flag somewhere that there ought to be a stopgap. Somebody ought to be talking to somebody to know that, hey, we're about to step in a bunch of doo-doo here.
That's the
Because
point
if
of
this
this
guy gets out, he stands the potential of hurting somebody. So I hear you, but the bail ain't the only part of this.
But that's why we're here today.
Well, no, that may be why you're here today. I'm here today to find a fix to this very big problem that affects innocent people, not just physically if they happen to be a victim, but psychologically because of the fear of being a victim. We've got a system that is not functioning. We've got a criminal justice system that seems more intent on protecting criminals than it is on keeping victims and others safe. That is a problem. Now, I have no issues whatsoever. I'm not throwing bricks at anybody, but there's an apparent disconnect that we have to fix. Violent offenders who have a history of demonstrating their violent propensities should not be allowed to run around willy-nilly, whether or not it's with an ankle monitor or not. They should not be allowed to come out here and victimize anybody else. Now, the case that you're talking about is a very unfortunate and tragic one, but unfortunately, it ain't the only one. Unfortunately, it's happened too many times, and I'm going to commend you for picking up other violent offenders before they had a chance to do something different. They had to add to their list of violence. If you got 6 pages, I'm glad you got them before you got to 7. But at the end of the day, there has to be a multi-tiered approach to fixing this. Now, some of this stuff to me, I'm not a criminologist, I'm not a police officer, I have no knowledge of the technical aspects of ankle monitoring, but I can add 1 and 1 and get 2. I can think in very simple terms, and one of the simplest terms there needs to be, there is no way that you ought to not have a liaison, a contact. Every single person that is released on electronic monitoring in Orleans Parish, NOPD ought to have a knowledge of that and know that they're at XYZ Street and at house 123 on XYZ Street.
That's
There is no way to rationalize that away.
That's
and
why
if
we're
we can
here
start
today.
taking these simple steps, if we start taking the small steps first, then as we get to the bigger ones, they won't be as big. And again, I'm not a criminologist, but I might not be the brightest bulb in the chandelier, but I'm far from the dullest. And if we take those simple steps, we can get to getting this problem fixed sooner than later.
And I just want to remind the council that the whole thing that brought this to light is not about the over 170 people we have on monitor and the thousands of people we have monitored over the last 6 years. It's about the one person that didn't make it into the program. And yes, there may be others. But I just wanted to make sure before we move forward that we understood that we're not talking about a news story that happened or a murder that happened or a loss of life that happened with somebody that was being monitored pre-trial or post-conviction. We're talking about a communication gap that caused that person to be released without a supervision program in place.
And that's why our first slide is about communication.
Well,
That's all
I
we're
just
missing.
got a call from the superintendent of the New Orleans Police Department, who has given me a number to give to you. So I would ask when you all wrap this, and actually we can wrap this sooner than later, because that's already progress,
Yes.
that
Absolutely.
we can get that done. And if we continue to take these steps towards progress, we will get what we need to get. So Matthew has a number to give to you as soon as you all finish.
Yes, sir.
And that is directly from the superintendent, who just called to say he is 100% amenable and very supportive of the idea of having you all give them that information so NOBT can function better.
So Jay, just on that note, and it's great that we were able to get this moving forward for this case, but I think going back to the conversation about setting up standards of procedures, and that way, you know, what if they're not at the table? What if another organization, another company has a client that they need assistance? So I think if we put those measures in place, everybody have that access to NOPD or whichever department they need to address that concern.
And that standard, I'm asking that Adam let us know who needs to establish that. If we've got the legislative authority to establish it from the local ordinance level, then 100% let's do that now.
Yeah.
All right, we can get that drafted for the next council meeting. If it has to come through the legislature, that's a whole different process. Or I'm going to ask that we do sit and have conversations with the chief judge and the administrators over there to get them, even if it's not a legislatively mandated standard, there ought to be some standard, because just like the gentleman pointed out, an experienced judge will know more than an inexperienced
Right.
one. So it may not have been done out of malice, but out of lack of knowledge. So we need to have that standard so you don't run that risk of having something like that happen again.
No, I agree. And I just wanted to make sure that we stay on focus on that.
Yes, ma'am.
Thank you.
Councilmember Glapion.
Just wanted to say, I can't imagine that a monthly report is even still relevant by the time it's received. So that absolutely can't be the only tool that we have to let NOPD know who's on electronic monitoring. So I'm just
No, the first of all, the standards that we've created are not designed to do anything except protect the hard work that Court Watch NOLA did, to ensure that we're never sending people to one program, that we're establishing a baseline for all programs. That way you can get the greatest bang for your buck, for, if you will. But as for what our reporting standards, there's 5 types of reports. You have the enrollment, which is the moment a guy goes in the program, you know it. If you're the judge, you know he got out, you know he's in the program. We can tailor that to go to whoever you want. The minute you hit submit on the computer, it goes to whatever emails you put in the system, and you can change that however you need. The second type of report is the actual court date report, which is a report that goes out on every single court date. That's primarily for the judge, the defense, and the prosecution. And it details anything that happened between the last report and this court date. And then the next report is a violation report, and that is an instant notification of anything they've done wrong. So that's going to go to whoever the players are. Again, the judge. The judge may want it to go to their clerk. It may go to the DA. If NOPD's in the loop, they may want to know that, and we would add them to that loop, especially if it's in a district. You know, the districts might want to know that. The next type of report is the whatever the heck report you want report. Just tell me what you want, we'll make it come out. And then the last report is a proximity. So there's actually, 5 different types of reports that should be standard. Remember, if this practice was in place, if this standard was in place, then the judge could have went, Andre's out, I ordered him to an ankle monitor, this is the day he was enrolled, here's the email. But they didn't have that. They didn't have that on Andre. Anybody, the DA would have had it in their monthly summary. The clerk would have had it in their enrollment notice. I mean, there's 5 different ways to make sure you get this information.
And to answer your question specifically, the enrollment report. The minute I am able to make the communication that the council has made available to us, it will be an enrollment report sent at the time a person is enrolled into the program,
And that
and
will
the
go to
email
NOPD.
would, yes, ma'am.
Okay, but
And
that is
then
not happening now, though.
It is
correct?
not happening
Okay.
now, no, ma'am. There's no communication
form
with
of that.
NOPD, yes, ma'am. And then the monthly report.
Okay.
So they'll get it immediately upon enrollment, and then every month they'll get an update.
So right now, tell me about a little bit more about the monthly report. So that is a summary of the month's enrollment that the NOPD receives.
At the time, on the 15th of every month, whoever is in the program on that day, a report is processed. That report will include the defendant's name, the date of birth, the division of court, the case number, and the conditions that are set by the court.
So it's current as of that date.
Yes, ma'am.
But between the 15th and the next month, there's nothing that updates that list.
Well, the
NOPD.
enrollment, right, the enrollment would let them know that someone new has been added into the program. Now, if there's a conditions change, then that would be an update conditions form, and that would be a new communication that would be immediately rectified. And whenever a judge updates someone's conditions, say they go from home incarceration to a curfew, then NOPD would be in that loop as well.
And I'd like to add one thing with that. We can tailor our system any way you want. The monthly report can be added to a live Excel spreadsheet, and the emails that it's sent to, they'll be able to click on that email whenever and see a live updated spreadsheet real time. So it's easy to transfer it over to that. We don't do it that way now because we don't have the communication bridge established. But if NOPD wanted a live real-time spreadsheet, we would create a live real-time spreadsheet.
Okay. And how quick can that be done? The
It'll
live.
be done before I go home today.
Okay. So NOPD can get a live spreadsheet by
And they can get an
tomorrow.
absolute live real-time spreadsheet of every single person in our program. Interesting, I sat with the 8th District and I watched a whole gaggle of police officers surround me reading the names and telling me the descriptions of each person. They know these people. They know who they are. They know what they mean to the community. I was shocked to hear some of the things I heard. There was concern by a lot of NOPD officers as to the level of people that are on our streets right now. They were shocked. They were shocked at some of the names that are out of jail, and I agree with you. But that's not my job. I don't get to stand over these people and say, you're too bad to be out, you got to stay. I'm not an elected person. I'm not the judge. I'm not NOPD. I'm just going to do what y'all tell me to do, and that's it. So, I mean, I hear you. I hear
Well,
what you're
Chair,
saying.
I think we would
But
ask
we make
that
it worse by not
they make that
communicating.
happen when they speak to
The
Chief Burton.
conversation with the superintendent is going to happen today. I've gotten that from Sean, so as soon as they finish, they'll be able to call him. We've got public comments. I've got 3 cards, and I understand.